present. All right, I've gotten a copy of the report. I've read it. Any additional evidence from either side?
Nothing from the people.
Nothing from defense, Judge.
This time I would on the evidence before we went competence trial at this time, but likely to attain competency through a prescribed course of treatment. And so I will, when I get a copy of an order, I'll
Yes.
sign that order. I'll set a competency review hearing for 90.
Okay.
July 9th, 2026, 9 a.m. bond continued.
Thank you, Judge. I'll get that order over to you right now.
Thank you. Court does call the case of the people versus Stefan Wainwright.
Good morning, everybody.
Okay. Hello, Mr. Wainwright.
Stephanie Can on behalf of Mr. Wainwright. Your Honor, there has been a finding of competency in this case. I am not going to stipulate to it.
Or not.
No, Your Honor. It says, however, he declined to proceed evaluation, stating that he had already resolved the cases and was awaiting release from jail. None of that is correct. None of that is correct. He has not resolved any of his cases. This would be page 3, the first paragraph.
Okay.
He actually did not participate in the interview. He stated he understood who she was and apparently turned around and faced the door until.
He stated he understood who she was and apparently turned around and faced the door until somebody came and got him. And yet he thinks the cases have been resolved. How can my client help me?
Somebody came and got him. And so he or she used previous information to say he's competent, and yet he thinks the cases have been resolved. How can my client help me?
Well, I don't know.
This
So
with that
what do you
finding?
for me to do
Your Honor, I'm going to ask.
for a competency hearing, but
Your Honor, yeah, we can set it for an actual hearing regarding the matter of competency. I'm going to see if I can work with my office, maybe getting a second opinion. It baffles me that they were able to find him competent. When I met with him yesterday, he came in, looked at me, and stared at the metal table while I talked. And then that was it.
how much time would it take you to get that? I have orders for competency, but I've already signed those and they've already issued their opinion. So,
Your Honor, I'm going to see if I can get a second opinion on the matter. I will file the paperwork today.
so how much time do you think?
It'll probably take a week, maybe 10 days to get the approval, at which point we will submit the information to the court so that we can get it to our.
Well, why don't I do this? Give me a date.
It's the beginning of June,
Yes.
June 4th.
All right. I'll set this for June 4th, 2026, 9 a.m. If it looks like it will not be done, then that's for a contested competency hearing.
Thank you so much, Your Honor.
Bond will continue. Thank you.
Thank you.
Thank you, sir.
Anna Mackey on behalf of Mrs. Greer.
Greer, can you state your name, please?
Zaya Greer.
What are we doing?
Your Honor, would like to adjourn this matter. We're
Pardon?
still waiting for discovery.
Adjourn it?
Yes.
Do I get a green sheet or no?
Miss Gaines was supposed to fill them out, and
This game.
I've seen the way.
Do not try to throw her under the bus.
So I was hoping
This is all your fault. Miss Gaines would never forget.
just a few cases earlier you waived her green. So I was hoping you could do this.
I was waiting for a green sheet from Miss Gaines. Right? Yeah. Okay. We'll adjourn. How much time did she need?
We're just waiting for some discovery, Your Honor. So 2 weeks should be fine.
And Your Honor, I did reach out for that discovery actually back in March for the sheriff's office. I still haven't gotten any response from them. Yeah, I'm going to continue to reach out to them. I don't know how long it take them to get back to me on that. Hopefully.
Okay, so let me do April 30th, 2026, 9 a.m. at this point.
Thank you, Your Honor.
bond will continue. All right, thank you, Ms. Greer.
Thank you.
Sure.
Let's just do this now. Why am I just getting it? It's not your fault. Don't worry about it. You're good. Bukovich? Whose fault is it that I'm just getting this?
To Mr. Bukovich's credit, he really did wear me down this morning, so.
Yes.
Why are you trying to save everybody? Everybody, you know what? Fine.
And I wasn't going to throw anyone under the bus. So
You will when those tire treads go over you. But all right. So what I have here is I have a plea form that indicates that the defendant will be pleading guilty to 2 charges, which is the stated count 2 of domestic violence, the 93-day offense, and to count 5 of attempted resisting and obstructing, the 1-year offense. Upon a successful plea to counts 2 and 5, counts 1, 3, and 4 would be dismissed. The defendant is agreeing to continue mental health treatment as recommended by his mental health professionals. There's also an agreement between prosecutor and defendant. Prosecutor will recommend the DV plea placed under 7694A, and that the attempted resisting and obstruction be a prosecutor's deferred sentence. That's the court's full understanding.
That's correct, Your
that's correct, Your Honor.
May I have the defendant sworn?
Right hand. You solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Lower your hand. State your first and last name for the record, please.
Nicholas Harding.
All right. Sir, it is this court's understanding that you're going to plead to 2 misdemeanor charges. Is that your understanding?
That's correct.
First of all, this court's understanding you're going to plead to the charge of domestic violence. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court cost. Do you understand that?
I do.
All right. And also that you're going to plead to an added count 5 of attempted resisting and obstructing a police officer or first responder. That's a misdemeanor punishable by up to 1 year incarceration, a $1,000 fine plus court cost. Do you understand that?
I understand.
All right. You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge in this case, and you would be sentenced before Judge Perry in the 15th District Court.
Yes, I understand.
Still wish to plead guilty?
I do.
To the charge of domestic violence, how do you plead?
Guilty.
To the charge of attempted resisting and obstructing, how do you plead?
Guilty.
You understand that by pleading guilty, you will not have a trial of any kind.
Yes,
You signed an advice of rights form?
I did.
Any question regarding those rights?
No, sir.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights of men.
I do.
You understand you're giving up your right to appeal of right.
I do.
Are you on probation or parole?
Probation.
All right. Were you on probation at the time of this offense? All right. You understand that your entry of a plea in this case could be a violation of that probation. You understand that as such, that court could sentence you to the maximum allowable under those other charges. And understanding that, you still wish to plead guilty to these charges.
I do.
Has anybody promised you anything other than what's been stated here today?
No, Your Honor.
Has anybody threatened you or coerced you?
No, sir.
You're doing this voluntarily
I am.
of your own free will. And because you believe that you are indeed guilty of these offenses?
Yes.
On the date of November 4th, 2025, at the location of 1501 Briarwood Circle, City of Ann Arbor, Washtenaw County, State of Michigan, what'd you do involving a Joe Y. Kwan that makes you think that you're guilty?
I made a threat while under I made a pretty alarming threat to the individual under question.
All right. And this individual, and it would cause them to have fear that you would do something.
I'm sorry.
It would cause you to.
Them to believe that you would do something to them. Is that correct?
Yes.
All right. And this individual you had a dating relationship with?
Yes.
All right. And did the police arrive at some point?
They did.
All right. And so you came into contact with Ann Arbor Police?
Mm-hmm.
Yes?
Yes.
Okay. And what happened?
It was under my assumption we were asked to leave the property And
Leave Howard Cooper.
I'm sorry.
You were asked to leave the property.
Yep.
Okay.
And after some time, I was not well mentally at that moment.
But what happened with the police?
Um,
When they were trying to take you into custody after you were arrested, did you attempt to pull away from the police
Yes,
officers?
I did.
Okay. So you knew that they were trying to arrest you and you attempted to pull away.
Pull away.
Or move away.
Yeah.
Instruct what they were trying to do.
Mhm.
All right. So I do have to advise you that if between the time I accept your plea and the time of your sentence, you commit misconduct as defined by the Michigan court rules, that you would not be entitled to withdraw your plea and the court would not be bound by any sentence evaluation or recommendation. Understand?
I understand.
All right, counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
Okay, thank you.
No, Your Honor.
And have I complied with the court?
We're satisfied, Your Honor.
The defense is satisfied, Your Honor.
Court will accept the defendant's plea to counts 2 and 5. Counts 1, 3, and 4 are dismissed. Pre-sentence investigation and report is ordered at 15 court probation. Sentencing will be
April 29th at 8:30.
April 29, 2026, 8:30. That's before Judge Perry. Bond with its conditions will continue.
As you may address one bond condition, Your Honor.
One,
Yes.
issue a bond
Yes.
after you give me sheets late and everything? Sure, go ahead.
Yeah, Honor, my client would be asking for the consideration of the removal of the tether. He has been on that tether since November without any other issues. He has been doing great work as it relates to his mental health treatment. That was a big consideration on why this offer was extended by the prosecution. The excellent mitigation report written by my mitigation team. So I would just ask for the consideration of the removal of the tether because it is, he has been complying on it since he's been placed on it, and it is producing a financial burden. I do understand if you want to leave that decision for the sentencing judge, and I did discuss that with my client.
Your Honor, Mr. Buckovich is absolutely correct. That was something, that how well Mr. Hardy has been doing and during the process of this case is definitely something that we considered when making this offer. Your Honor is more than well aware that Mr. Hardy has come to every proceeding, has been respectful, has done just about everything. I would defer to the court in this decision. I think there is a defendant.
For the people?
Assistant Public Defender Donald Lee on behalf of Ms. Hickman. Ms. Hickman, can you tell the judge your name, please?
Randy Hickman.
All right, take your hands out of your pockets.
And Your Honor, we would like to set this matter for preliminary examination.
I don't need this green sheet. You're just,
Yes, Your Honor.
yes, Your Honor, what?
Yes, Your Honor, you may disregard the green sheet. Thank you.
Is discovery complete?
It is.
People have their witnesses available the 21st.
Your best, Your Honor.
Preliminary examination in person, April 21st, 2026, 9 a.m. before Judge Garwood.
Thank you, Your Honor.
21st.
Bond will continue.
9 a.m. Second person.
I don't think I can take time off of.
Thank you, ma'am. Good. Wow. I am impressed by me. Why are you handing me more green sheets?
The ones from before.
Oh, the ones you didn't get to me.
Yes.
It's like a deck of, that's like a huge pile.
For 12:30 on the head.
Okay. Why don't you get them to Miss Wyfern in there?
All of the prior ones.
What did I say? What was? Buckovich, would you have questioned me if I had said that? That does that. We're actually going to get a break, which is good. All right, we'll court of state in recess till our next block. Thank you.
What makes this case so gripping isn't just the charges. It's the question of whether the system truly understands the person standing in front of it. When competency is in doubt, everything changes because the law isn't just about guilt, it's about fairness. If someone can't assist in their own defense, should they even be moving forward in court? This hearing shows how quickly legal certainty can turn into doubt. And now the real question is, Did the court act too fast? Or is this just a delay tactic? What do you think justice looks like in a case like this?